Let me know when to begin all the formalities.
Make sure I'm unmuted also. There we go. Or, yeah.
Is it Rosie or Rosie?
Rosie.
Rosie.
You worked with me for like a month, man.
And I always pronounced it Rosie, so
Yeah, and I always correct you.
yeah. All right, Rosie.
Let's see.
Let me know when to begin all the formalities.
All right,
Let me know
yeah.
when to begin all the formalities. All right, are we ready?
Well, I have this. It's live, but I mean, I need to get the stream out.
All right, tell me once it's out, and I'll start.
Let's do. Let's begin in like 2 minutes so we can get people to come in. Okay. Let's see. I'm waiting for it to get up to about 8 people watching. It's on 4 right now. And then I'll kind of, we'll get it started.
All right, let's go ahead and go mic silent until it officially starts, and just type in the chat when it.
Okay. Okay. Everyone can unmute now. So basically, what we're going to do with this case, the two justices that were going to come here and listen to the arguments was Emperos and Benjamin. They're both not here, but we're going to take their votes after they listen to the recording of the case. Is my mic muted? No, everyone can hear me. Let's see. Take their votes. Yeah. So
All right. I will now call to order the case of the Supreme Court hearing of the United States v. James Rozie. We will start off with opening statements. The prosecution may begin.
Good evening. Tonight, the Department of Justice is questioning the grounds of James RozeeJr. Jr.'s recent run for office. This is mainly about his violation of the 12th Amendment. In the 12th Amendment of our Constitution, it states, "No person shall be representative in Congress, President, Vice President, or hold any office, civil or military, under the United States, who, having previously taken an oath as a member of Congress, or a judicial office, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." The operative clause being given aid or comfort to the enemies thereof. In today's English, this means that anyone who previously took an oath of governmental office and broke that oath by committing treason shall not be permitted to hold office again. As shown in Exhibit C, Mr. Rozee took an oath to defend the Constitution when entering the House of Representatives on July 2nd, 2015. On July 7th, 2016, Mr. Rozee was convicted by the Supreme Court of treason under H.R. 701 for leaking
I
classified
would like to
CIA.
correct you for a moment there, if I may. He was convicted
By the
under
federal court, right?
Justice Clement.
Yes, just alright, my bad. Under H.R. 701 for leaking classified CIA documents, as shown in Exhibit E. This charge was never expunged when James N. Reed terminated the sentences, including Mr. Rozee, on August 24th of 2016, as shown in Exhibit F. The operative clause for this case in definition for treason, according to H.R. 701, is adhering to their enemies and giving them aid and comfort. By leaking classified, sensitive documents, Mr. Rozee gave way to pro-NUSA propaganda, as shown in Exhibit D. We could assume that this helped NUSA and comforted them, satisfying the last term of H.R. 701's treason definition of giving aid and comfort to our enemies. However, humiliation on the international level by his leaks is only what we publicly know about the consequences of Mr. Rozee's actions, to say nothing of the countless enemies of our country and foreign nations who can no longer recognize EUSA as a legitimate entity because of Mr. Rozee's irresponsible leaks. Mr. Rozee will claim, Your Honors, that what he did was the very opposite of treason, that it revealed the illegal actions of our former president, Mr. Siegwald, and that his leaks provided the information on which grounds Mr. Siegwald was impeached. However, do not be deceived by that statement. While Mr. Rozee may have felt he had an obligation to report this information, he should have given it to a secure committee of Congress as classified information for grounds of impeachment, or surrendered it to a federal attorney as classified information for grounds of prosecution, or even filed a lawsuit in his own name against the president and entered it as classified information. However, he did not do any of these things that would keep the information classified. Had he taken a more cautious route like these examples I have given, he would have been able to impeach Mr. Siegwald while not leaking our country's classified information to the entire world. But rather than being responsible with the sensitive intel he was given, he completely disregarded the fact that it was classified, thereby humiliating the country on a world stage, aiding our enemies, and sowing distrust in the hearts of the citizens. The reason he was convicted of treason was not because he dared to use the information to impeach the president, but because he dared to treat it as unimportant and disregard the oath he took to protect the United States by leaking the once again classified information to the entire world and discrediting the reputation of our country. In every aspect of the crime, in every aspect of the definition of the crime, Mr. Rozee committed treason. Therefore, allowing a convicted traitor to run for and hold public office in the country he betrayed is not only a direct violation of the 12th Amendment of our Constitution, it is a degradation of the entire judicial process we use tonight to discuss his actions. Thank you.
Thank you. James Rozeee Jr., you may begin your opening statement.
Thank you. The gentleman across from me is very well correct that I did make an oath to uphold the Constitution, and uphold the Constitution is exactly what I God well did. Now, I also made a pledge to uphold the laws, but when our national security laws conflict with the Fifth Amendment, then how can you uphold the Constitution and the laws? The legal pyramid, which is very clear, saying that the Constitution is at the direct top and takes precedence over congressional statutes, such as, for example, the Patriot Act, clearly it outlines that the Constitution takes precedence. Thereof, the Fifth Amendment was being violated. There was utter disregard for the law within the Segwald administration and from my superiors within the Central Intelligence Agency. I'd also like to remind the gentleman across from me that there was no documents labeled classified in which I released. Now, the fact is, I could have sent it to a congressional committee, but the House was in absolute upheaval. It was, at the time, run by Democrats, the party of Mr. Segwald, and the Senate was run by the Democratic Progressives and the Democrats, the party of Mr. Segwald, and the party of Mr. Warren, neither of which would have done anything. So the only proper way to uphold the Constitution was releasing the documents, so public outrage would have demanded Segwald's removal, which it worked. Now, I understand it's very hard for you, Mr. Attorney General, to understand how to actually remove a president. I mean, I've done 2 now, so you can trust my judgment here saying that this was the proper action. Now, it's very easy to use me as a scapegoat for our lack of international recognition. But the fact is, we didn't have recognition to begin with. Nations did not respect us as an entity to begin with. You cannot blame my leaked Central Intelligence documents simply on the fact that we no longer have international recognition. When Mr. Walsh and Ms. Hartson left is when we lost our international recognition. At the same time, I did not provide comfort to our enemies. There was no intent present. Now, I'm going to move on next to the fact that it was declared Reed's declared that I was mistrialed, and that's why I was released early. But how would this sentence still apply if I was mistrialed to begin with? Why would that still remain on my record? If I was never properly and duly convicted of treason, then were my constitutional Bill of Rights upheld? If so, then this 12th Amendment shot is below the belt in its complete entirety. Reed said that I could run for the Congress, implying that, at the same time, saying that I was not properly convicted. Listen, if you cut a tree off at the stump, the rest of the tree comes down with it. If I wasn't properly convicted, then I'm not a traitor. You can't uphold, there's no floating branches when you take down a tree in the real world. Now, the fact that the other justices are going to get a vote here when they're not present it's very privative of our judicial system. If you can't show up, you're not willing to ask questions and do your job, why are you on your seat? To extend further, Mr. Jones, you were involved in the cover-up with Mr. Segwald. You testified against me at this court. Why have you not recused yourself? The bias and just the stacking being done on the court right now, this case is nothing more than a political showpiece.
May
right
I ask
now.
a
It's
question?
absolutely disgusting.
And
Let me finish.
This is on a previous matter. This has nothing to do with the bias or whatever.
Allow me to finish my opening statement.
You're kind of
Justice,
going
and
off
we'll
topic,
finish.
but go ahead.
We will allow.
No,
we will
but
allow
here's the
Mr. Rosie
fact.
to finish.
I'm saying the emperor has no clothes, and now I'm being told to shut up. And today's English, listen. When you start deviating from the actual text that was written, that's when we start getting judicial activism. So don't take today's English, Leo. And to begin with, the 12th Amendment has nothing to do with intelligence leaks. It was to prevent Confederate politicians and soldiers from serving in the U.S. government, to protect blacks. That's what the 12th, 13th, and 14th Amendments were, to protect black people and former slaves. And you're using it as some type of loophole to prosecute me. It's absolutely disgusting. There. I close.
Okay, I have a question.
Thank you, Mr. Rosie.
I do have one question about, you stated that you're protected by the Fifth Amendment to leak the documents, correct?
No, I didn't claim that.
Or I'm sorry, you were talking about the Fifth Amendment earlier. Could you talk about, and you were kind of going back to the case that was decided at the federal courts. Can you kind of reiterate what you were saying there?
I wasn't the one that originally brought it up. The gentleman across from me brought it up, so I decided I'd argue on that. The Fifth Amendment states that I'm entitled to a fair trial, and Mr. Reed deemed I did not receive a fair trial. So if I did not receive a fair trial, I was not duly convicted of treason. So I'm still not completely aware on why the treason charges remain on my record.
Can I?
Mr.
It's
Rosie.
Do you have
more
documentation that he says that there was a mistrial?
well, no, I have the fact that he said that I was not properly trialed, and that
But do
is
you
a
have
mistrial.
that? Do you have it? Do you have it
Mr.
on
Mr.
Oh, no, I'm
documentation?
really curious on why you want specifics here, but you don't want specifics anywhere else. In today's English,
Well, no, I haven't even asked other. I have several other questions I'm going to
Justice
ask.
Terrence.
But
if-
I
if
if I was not
Just-
properly trialed, I was mistrialed, and that's what
Mr.
I'm
Rosie,
pleading.
but is it
was
documented?
the judge of your trial? Did Justice Clements declare your trial mistrial?
No, because the guy obviously had it in the bag for me, and the trial was
It is
nothing
the
more than
job
a
of
similar
the judge or
trial.
justice of your trial to declare it a mistrial, Mr.
Right.
Rosie. If he did not declare it a mistrial himself, then the verdict or ruling of the jury will stand.
I also have
All right.
another.
All right.
I also have another question. You talked
ahead, Mr.
about
Chairman.
how Mapp said that your trial was a mistrial, but in the documentation, I'm not.
said it was
No,
mistrial.
hold on.
I'm
No,
done here,
no,
Clemens.
no. Hold on a second.
Both of you, please.
In the
I-
documentation presented by Mr. Reed, it says to clarify, their sentences have simply been ended as of today. The crimes shall remain on their record.
Let's go back to the original document, though. What I'm saying is his documents contradict each other, Mr. Walsh.
Okay, can I see this other document?
I don't have the other document.
Oh.
I was made aware of this trial about 30 minutes ago.
Well, no, this trial has actually been in the federal courts for a very long time.
I was made aware of this trial 30 minutes ago.
Okay,
All right.
that's the fault of the Department of Justice, not us. We're just examining the evidence.
Thank you, Justice Terrence, for your questions, and
Mhm.
thank you, Mr. Rosie, for your answers. We will now continue in a more formal fashion. The prosecution may begin with their case. Do you have any witnesses?
No.
All right. Does the defense have any witnesses to call forth?
No, I was made aware of this trial 30 minutes ago, Justice.
Understood.
So I would like to rebut on what
I
Mr. Rosie said.
suppose we will allow that.
All right. So Mr. Rosie has mentioned that our overseer James Reed cut his sentence short. However, he seems to have misconstrued this as a declaration of his trial as a mistrial, but that's not the case.
I did not claim that, sir. I said.
I'm not
I
finished.
said-
I'm not
Hey,
finished.
Leo's
No, but
speaking.
you just.
No.
I never said that it was a mistrial.
Rosie,
Please,
Rosie, let
Mr.
Leo's.
Rosie,
Let Leo's.
please
You'll
wait
have the chance
until-
to speak in a minute.
Mr. Reed realized that while showing discovery files 24 hours prior to a case's proper is not likely to have completely thrown the trial askew. The very statement he issued alongside the release of
Mr.
Rosie
Reed realized
and
that
others
while
included
to
the fact that
completely
his
throwing the
pardon,
trial
quote
askew.
unquote, only cuts their sentences down, but it did not remove the crime from the record. Mr. Rosie has simply misunderstood this as declaring his trial as a mistrial, but that is entirely in conflict of Mr. Reed's pardon statement. Furthermore, I'd like to remind you, Your Honors, that this trial is not discussing whether or not the prior trial was a mistrial, but whether or not Mr. Rosie is permitted to run for public office. Legal logic is sound. Mr. Reed did not declare Mr. Rosie's trial a mistrial. He only said that his sentence was terminated and his charges were going to remain on record. Since he is guilty of treason, he cannot run for public office pursuant to the 12th Amendment. Thank you.
And I just
Thank you.
wanted to
Mr.
add.
Rosie, as you.
I just wanted to add something
Yes, Justice Terrence.
real quickly. People are. I just wanted to clear up how apparently we haven't made people aware within 24 hours of the trial. It has been on public record for 2 days now, all the evidence for this trial, who's going to be involved in this trial. So it was possible for the prosecution and the defense to know that this trial was occurring because this was posted in the court docket 2 days ago. Just wanted to clear that up.
Yeah, John F. Kennedy should have been aware
Thank you,
of Harvey
Justice.
Oswald. I get what you're saying exactly.
All right, Mr. Rosie, as you were trying to rebut earlier while the prosecution was making their statement, what were you stating?
I'm simply stating that Reed's two statements completely contradict one another. He simply put the second one in to appease the political left. Now, he originally said that due to mishandling of my court case, that gives grounds for a mistrial. Because he
However,
simply
Mr. Rosie,
completely...
did
I've not been
Justice
listen. I've been attempting to file a mistrial, but the fact is, the Attorney General and the Department of Justice has all but simply ignored me for it.
to file
I
a
have not
mistrial,
had the chance
Mr.
upon my
Rosie,
return to properly file for a mistrial.
to file for a mistrial, Mr. Rosie, it is a motion made post-trial.
I'm an actual law student, not an internet pseudo lawyer. I don't need you to tell me what a mistrial is. And at the same time, I do not yet understand why you have yet to recuse yourself on this trial. Now-
Oh, you're not finished. Sorry.
No, go ahead, Leo.
All right. I'd like to point out that Mr. Reed never said that this was grounds for a mistrial.
No, his wording implied that it was grounds for mistrial.
So
Because he
was
said
there?
that my
There's
court
no
case
direct
was
quote.
mishandled. If a court case is mishandled, then that means it's in violation of my Fifth Amendment rights for the sentencing to remain. Because I was not given a fair and proper trial.
I see. But Mr. Rosie, we can't, though James M. Reed is a high figure in our country, we can't hold his opinion higher than the justice ruling the trial, regardless of who it is. If the President of the
It
United
was not a
States...
fair trial. That's what the argument was. And he's absolutely correct.
And I understand this argument, but until
And
the
again, I
judge
simply do
or
not understand
justice...
why you're here when you should have recused yourself because your involvement with the case.
This is still irrelevant.
No, it's completely
Mr.
relevant.
Rosie,
It's not.
I will speak
no.
to this
Listen,
matter.
hold on 1 second. This case is to argue whether or not you are allowed to be in those particular offices under the
The
12th
only thing
Amendment,
that public
not whether or not
asked
Martin
was
should
the reason
recuse
he was
himself
allowed
from
to come
this
back to this
case.
court was the fact that I was sentenced to treason.
Okay.
Okay.
Was there a
If
mistrial?
I have not yet had the ability to file for a mistrial because I've been in federal prison and the Department of Justice has blocked my attempts to file. I've said this twice now.
Have
I
you
need
have
to
you
issue-
has the presiding judge's private messages been closed?
No.
Okay. Then you had the opportunity to present.
No. The thing is, the Department of Justice does not have any public defenders, nor does it have any real way to contact them, other than PM.
But you can contact the judge yourself.
Okay, I
to
would like
defend
to... This is going in circles, so I will... Let's move on. Does the prosecution have any other case they would like to make, or can we move on to the defense and their case and argument?
Well, I'd like to quickly point out that he's saying that he didn't have a chance to file for mistrial, but due to the fact that he did not file for it at all, it's not mistrial. So I just want to say that you can't run for public office.
All right, thank you, Mr.
So
Leo.
where did I exactly break the Fifth Amendment, Mr. Attorney General?
I never said that, sir.
Or not the Fifth, the 12th Amendment.
When it says, given aid or comfort to the enemies thereof.
Given aid or comfort to the enemies, therefore.
Actually,
you understand that clause
Mr.
specifically has been defined by the real Supreme Court as like housing enemy troops, correct? I did not house enemy troops, Mr. Attorney General. And if you were aware of the actual context from the rulings, from the rulings on the 12th Amendment, you'd be perfectly aware.
Mr. Attorney General, I have a question.
Yeah.
Can you define treason for me?
I
I know the definition, but can you give me your the definition you have?
According to
to U.S. Code.
U.S. Code.
I have it right in front of me if you'd like it.
All right, Mr. Rosie, we will continue on to
Oh.
hear out your main case and argument over why you are not violating the 12th Amendment of the United States Constitution.
Am I allowed to speak, or?
Do you have that definition?
Yes,
Leo?
please go ahead.
Oh, I had.
Okay, no, I thought he was waiting for the definition of for the.
Oh. You want me to say it?
I thought he was waiting for
Yeah,
2381.
Yeah, Leo, can you read that out?
I can read 2381 if you want, Terrence.
Whoever owing
Go ahead.
allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere.
Okay. And that's in
Mr. Rosie?
portions of the 12th Amendment, isn't it?
Go ahead, Mr. Rosie.
Again, it's been very clearly outlined by the real Supreme Court that giving them aid and comfort within or elsewhere is housing enemy soldiers. It has absolutely nothing to do with. I don't get how I gave them aid or comfort. I didn't feed them or house them.
Well, the definition of treason is giving them aid and comfort.
Yeah, I did not do either or.
But you were found guilty of treason.
Yeah, and I'm curious on why that was.
So
Okay, well, that's
We are
not
not
for us
here
to
to
decide.
argue-
That was already decided.
we are not here
wasn't
to
it?
argue the verdict of that case.
Yeah,
We're
exactly.
here to argue after the verdict of guilty, Mr. Rosie. Why are you not violating the 12th Amendment?
I'm not violating the 12th Amendment because I did not adhere with violent insurrection or rebellion.
Okay, I'm done questioning. If you have any more questions, Martin, you can go ahead.
The 12th Amendment specifically bars you if you adhered with violent insurrection or rebellion. I mean, the Tea Party protests I held got a little shaky, but I wouldn't classify them as violent insurrection or rebellion.
All right.
Let me just I'll explain this a little bit further. Clause does not equal effect. The fact that I was declared guilty of treason does not mean me running for office if I did not give aid or comfort to the enemies, which is a specific section he's referenced. It says or adheres. I was convicted for treason because I declared an oath. Yes. Owing allegiances to the United States. Kaboom. I did not give them aid or comfort. I was convicted for the first section of treason, but the only overlap is the second section of treason. Thereof, I am non-violation of the 12th Amendment. Is that better?
Yeah, I understand your argument.
Okay.
I have no further questions. If you have any further points, either side.
May I butt in for a second?
Go ahead.
Mr. Rosie is not giving any adequate information explaining how he's permitted to run for public office. Instead, his entire argument is circling around an allegation that Justice Clement's ruling against us was unjust, which is entirely irrelevant.
I just made a completely other argument just prior there, but sure.
He did.
All right.
All right, Mr. Rosie, do you have any further points? I
Again,
believe I've understood the body of your points.
okay, all right. I've got nothing then. If I don't need any more counter rebuttals, I'll be fine.
Did I go past? Am I allowed to say one more point?
All right, yes, we will now begin our closing arguments.
Oh.
The prosecution may begin with theirs.
Right. In closing, Mr. Rosie committed a serious crime against this country. We are obligated to protect the integrity of our government by interpreting the Constitution word for word. Or from that, right, I'm reading it wrong. From that, I conclude that Mr. Rosie cannot run for and hold public office in this country, or it will be a violation of the 12th Amendment. Everything this country stands for.
Thank you. The
Okay, well-
defense may make their closing argument.
Everything this country stands for is liberty and the rule of law. I tried my best as the deputy director of the Central Intelligence Agency to uphold the law, in which the president very clearly defined, because if you look currently in the Oval Office, we have a Joseph Hamilton, not an Erwin Segwald. The fact is, this is a political trial simply orchestrated by the left to remove the strongest hitter, and absolutely nothing more. This would not be filed by a Democratic attorney general against a Republican congressman if there was not gain. There is severe gain for me to be barred from holding public or judicial office. The fact that you're sitting on the bench right now, Mr. Jones, when you're guilty of as many crimes as I am, and the fact that Segwald was ran out of the country shows that there is no basis for law in the country. And if you do rule in favor of the prosecution, you're simply forwarding the political aspirations of Mr. Hamilton and his cabinet by having me tossed back in prison and crippling the Republican Party for kicks.
Thank you, Mr. Rozee. With that, we will now have a recess of 24 hours.
24
And
hours.
upon the end of this recess, the judges or the justices of the United States Supreme Court shall state a ruling.
You can save the time. I know how it's going to turn out.
I'm not so sure.
Okay,
We will
we'll end the
begin and I
stream.
declare this court in recess. Thank you.
Is
gentlemen,
24
for
hours
attending.
completely necessary?
I don't believe it's
If
necessary.
you would like to request for a lesser recess,
I would. I mean, an hour would be, what a normal time over. I mean, I understand 24 hours in the real world because you have a lot to consider. We literally had we had
Okay,
a
I'm gonna end the stream by the way.
20-minute argument here. It's